Good evening to everybody. That is All India Bar Examination aspirants of the 2022 cohort 17. Karibu sana. Welcome in the Kiswahili and read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
Good evening to aspirants of All India Bar Examination 17-2022, Family Law.
Professor Doctor?
Professor Dr. Mohammed Saheb Hussain.
Yes, here is the man and here is a woman. And he is a girl child and a boy child. And what is this?
It's a family, sir.
Say.
It's a family.
Cursor, where I am showing cursor. You are not looking at the cursor.
Sir, that is a law. Law.
So there is a symbol for a judge to say order.
There is a name. A particular name is there for this one.
No idea, sir.
Yes, pass on. This is called G-A-V-E-L, gavel. And this is called sound plug or sound block. Okay, I will share you that so that did you see now? Did you see now?
Yes. We can view that.
What is the written there?
Very
here the cursor.
It's showing gavel and sound.
Block.
Yes.
It's a gavel, G-A-V-L, gavel and sound block. Where you hit the sound block for drawing the attention. Generally, who you use it?
The judge will use that for the audience and for the advocates.
Yes.
Everybody.
Yes. Even actioneer also use it. Actioneer.
Yes.
Yes. Now coming to our point without wasting the time. All India Bar Examination, it's the 17th cohort and 2022. And today family law consisting of the Hindu law, Muslim law and Christian law also. Multiple choice question. First question. What are the remedies available to the parties under the Hindu Marriage Act 1955? Number 1, restitution of conjugal rights. 2, judicial separation. 3, divorce. 4, all of the above.
All of the above, sir. All of the above.
For all of the above, sir.
Right answer. The 3 remedies available to the parties are restitution of conjugal rights, judicial separation, and divorce. And they may ask the question also in this way. They will keep 4 options at the left hand side, column A, and the 4 options in the right hand side, column B, and they will jumble it and they ask you to match the following. At that instance, you should know the full meaning of it so that we could match it. A supplementary question, that is. Number 2, when either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for dash. Number 1, judicial separation. Number 2, divorce. Number 3, restitution of conjugal rights. Number 4, all of the above.
The third one, restitution of conjugal rights.
The right answer is restitution of conjugal rights. That is the correct answer. Third question. Hindu covers not only persons who are Hindu by religion, but also those who are given below, but not religion, will not belong to Hindu. What is that? Number 1, Sikhs. Number 2, Parsis. Number 3, Buddhist. Number 4, Jains.
Parsis, sir. Parsis.
You are right. They are the Parsis. Because when you say Hindu, Buddhist comes, Sikhs will come, Jains will come, but not the Parsis, not the Jews, not the Muslims. Whatever the Christians, they don't come. under the umbrella of Hindu. Next, fourth question. The Indian Succession Act 1925 is identically applicable for testamentary succession across all religions, but not one dash. Which one is not relevant? Buddhists, Jews, Parsis, Muslims.
Buddhist, sir.
Did you understand the question first?
Muslims, sir. Muslims.
Muslims. The
Muslims
Indian
is
Succession
different.
Act 1925 is identically applicable for testamentary succession across all religions, but not one. Buddhist, yes, it is applicable. And Jews, yes, it is applicable. Parsis, yes, it is applicable. Testamentary, I am speaking. And Muslims, it will not be applicable. Supplementary question. Either testamentary or intestate, what law would be applicable to the Muslims in inheritance? Or in other words, we can say succession. What law would be applicable in
Muslim law, sir.
inheritance?
Shariat.
Shariat law, Quranic ratio is there, and which is always in divisible manner, half, 2 by 3rd, 1 by 4th, 2 by 8, and all those things. At that instance, Quranic shares are there, and according to that, the shares will be given to the persons. Suppose the shares are exhausted, then the other people will not going to get anything. Feedback. Sikhs, Jains, Buddhists, Christians, Jews, and Parsis, other than the Muslims, will come under the testamentary succession under the Indian Succession Act of 1925. The fifth question, anyone can unmute and read? What is the fifth question?
Fifth question, the dash amendments and the judicial decisions thereafter have clarified that a married daughter has a right over the property of her father, which is equal to that of a son. That one is 2004, sir, I think.
2005.
It is 2005 is the right answer.
Yeah.
At the time, who is the chief minister in the Andhra Pradesh?
NTR.
Yes, yes. Sixth
But that one is
Sir, 2005, no NTR, sir.
Chandrababu Naidu, sir. Chandrababu Naidu. Chandrababu Naidu.
No, is the initiated? No.
YSR.
No, YSR, sir. YSR.
In the 2005.
Chandrababu Naidu, sir.
See,
Sir, when the Hindu
equal rights have come
No.
to the even daughter
To
as
four
well
only
as the son.
Chandrababu was there.
Anyway, that no dispute. To my knowledge, is N.T. Ramarao. So anyway, let us see that. Who among them is not a co-partner? Number 1, Karta. Number 2, wife. Number 3, son. Number 4, grandson. Hindu undivided family, HUF.
wife, sir. Wife, I think.
Wife will not come under the co-partner, but wife
Yes.
can share from the property of the husband.
Husband.
It is a
Husband, yes.
HUF, husband HUF. And feedback. Under Hindu law, the co-partner is a term to indicate those who male members of a Hindu family. Say they clearly mentioned what male members of a Hindu family who have an undivided interest over the ancestral property by birth. They are the head of the family or Karta, and the 3 subsequent generations of the Karta, which includes his sons, grandsons, and great grandsons. That is the feedback. 7th question. A wife can be a member of her dash, but not a co-partner. Number 1, fathers, HUF. 2nd, brothers, HUF. 3rd, husbands, HUF. 4th, sisters, HUF.
I think sister
3,
HUF.
sir. 3.
I gave the answer while I was giving. A wife can become the husband HUF, I told already. I don't know whether you heard it or not. It is the answer is for the 7th question, husband's HUF, Hindu undivided family. That is the point. Okay. Feedback. A co-partner is a member of the Hindu undivided family, HUF within parentheses, including sons as well as the daughters, descended from a common ancestor. A wife can be a member of her husband's HUF, but not a co-partner. The HUF is led by a member known as the Karta, who is usually the eldest male member of the family. That is the answer. So, supplementary question. Can a child, a female would be a Karta? Yes. A female would be a Karta.
Yes, sir. Right now,
No,
can
no,
be a
no,
karta
no,
right
no.
now.
I think now question is they can have a partition, share in it. But I don't think that she is a Karta, a female is a.
As per Supreme Court judgments, it is there, sir. But
It is-
as per practice, it was not there.
Okay. As far the
After
theoretical principles are
recent
concerned, a
judgments.
Muslim man can have the 4 wives, but the practical aspect is concerned, 1 is equal to 4. So, eighth question. Eighth question. It is possible for the Hindus to marry without undergoing the Hindu marriage rituals and still remain Hindu for other aspects of the law. Answer yes. 2. No. 3. Hindu can opt for the civil marriage. 4. Only 1 and 3.
Sir, can you 1 minute, sir? It is possible.
I repeat the question. Is it possible for the Hindus to marry without undergoing Hindu marriage rituals and still remain Hindu for other aspects of the law? Number 1, yes.
Yes.
Number 2,
No,
Yes.
sir.
number 3, Hindu
Yes, sir.
for civil marriage. Number 4, only 1 and 3 correct.
I think yes, sir.
One, sir. One.
You have to
One
give
is
the
yes.
appropriate answer, the exact answer. I know it is yes.
Sir, because if Hindu girl can marry any person, actually it's not having any restriction after the marriage. Either she want to be a Hindu or either you want to be Hindu or
I
you want to
gave
convert
4
into.
options here. You have to speak on the 4 options only.
Yes, sir.
Sir, in Hindu marriage, there are different types of marriages. So we can
Don't
do.
give the explanation to me. I gave the 4 options. Which option is the right? Just give me the answer.
Sure, sir.
Answer is 4. Only 1 and 3. They can marry, yes. They can marry. Hindu can opt for the civil marriage also. Still, he could be a Hindu, and all other respect, he will be treated as a Hindu, and the law would be applicable. Here the answer is, 8th
Four.
question answer is 4. Only 1 and 3. That is the yes and 3. Hindu can opt for. So answer is 4. 8th question on multiple choice answer is 4. What are the options I have given? Based on the option, you have to pick it out. Yes, read. Anyone can read the 9th question. Unmute and read. 9th question, unmute and read. Participants.
Ninth question.
Ninth
Ninth
question.
question. The Special Marriage Act in dash clearly states the if a special or civil marriage takes place between two persons, both of whom are Hindus, Buddhists, Sikhs, or Jains, such persons continue to be governed by other aspects of Hindu personal law, such as the law relating to succession.
Which section of the Special Marriage Act deals? Section 21.
Section 21A.
Capital A. Section 21 capital B. Section 22 capital A. Answer is, make a hunch, anticipate, shoot.
Even is option B.
What is the option is the right answer here? Among 1, 2, 3, 4. Section 21 capital A. That is option 2 is the right answer. Option 2, section 21 capital A is the answer for the 9th question. Let us scroll to the, anyone can unmute and read. Tenth question.
Question number 10. In three situations, such a marriage is said to be void, which means that it is invalid as if it is never took place, but one is not related to it. Find out odd man out. Option 1. If one of the parties to the marriages as a living husband or wife. Option number 2. If one of the parties to the marriage does not have living husband or wife. Option number 3. If the parties are within the prohibited degree of relationship. Option number 4. If they are subpoenas of each others.
Yes. I have given the 4 options.
Number 2. Number 2, sir.
Number 2. If one of the parties to the marriage does not have a living husband or wife, it is not relevant to the question which is framed over there. So,
The one, sir.
no. If one of the
Sir, if
parties
one
to
of
the
the
marriage
parties
have a
to the
living husband
marriage
or
are-
wife, it is
Yeah.
said to be the void marriage or invalid marriage. It is amount to bigamy. And if the
Yes, sir,
parties
it's-
are within the
it's-
prohibited degree, it is an invalid marriage. If they are the subpoenas of each other, it is an invalid marriage.
Yes.
I say
Sir,
no.
I think
When I
Sir,
say
if
no,
the-
the right answer is option 2. But one is not related to. I say not related to. You did not observe it. Not related to. 1 is related to. 3 is related to. 4 is related to. But not 2. Is it clear? Say yes. Is it clear? Say yes. Is it clear?
Yes, sir.
Yes,
See,
yes,
I
sir.
cannot move unless I get the answer from you. I
Yes,
cannot move
sir.
unless I get the answer from you. So 10th, 11th question. The Indian Christian Marriage Act 1872, Act number dash of 1872. Number 1, 13. Number 2, option
14.
Number 3, 15. Number 4, 16. Unless I read the 4th answer, then only you have to give the reply. If you know it, don't give the reply when I'm reading the option. Yes, now you can. Now you can.
2, sir. Option 2.
Wrong.
14, sir.
14.
Sir, number 3.
Number 3, don't say 15. Number 3, that is the 15, is the right answer. For the question, 11th question. It is the way. So 12th question. Whereas it is expedient to consolidate and amend the law relating to the solemnization in India of the marriages of persons professing the Christian religion, it is hereby enacted as follows is in dash section. Number 1, section 2, class B. Number 2, section 3, class 2, Roman small 2. Number 3, preamble. Number 4, section 2, class A. Hindu Marriage Act, sir, Christian Marriage Act.
Option 1, sir.
No,
Number 2, sir.
no. It is the
Then I may be
preamble.
preambles.
I made the preamble and I gave the fabricated sections. to draw your attention towards that side. So answer for the 12th question is preamble. 13th question. Anyone can unmute and read.
Minor means a person who has not completed the age of dash and who is not a widower or the widow as per the Christian Marriage Act. 18 years, completed 18 years, 21 years, completion of 21 years.
Which is the right answer?
Completion
Option
18.
number 4, sir.
Completion of 21 years, sir. Fourth one is correct.
Option number 4.
The wordings are not given completion of 21 years. The wordings are given 21 years only. The wording is given there in the minor under the act is they did not mention the completion of 21 years. They mention only 21 years, and that to be 20-1 it is there. If you happen to check the Christian Marriage Act. Can I show you the Christian Marriage Act? I think I have downloaded it somewhere. No.
This act is recent now, sir. Recent act.
So now the exact
So under
answer
21
you have
is
to
a
say-
minor, above 21 is not a minor.
You have to say 21 years the right answer. Third question is the right answer to the question minor. When you are reading I quote, minor, I unquote, means a person who has not completed the age of dash. I say not completed the age of dash and who is not a widower and a widow as per the Christian Marriage Act. That means the appropriate is option 3, not option 4. Option 4 comes under the major, not a minor. Is it clear? Say yes.
Yes, sir.
Yes, sir. Yes.
Then only I can go further. Yes, 14th question. What is the primary purpose of Christian marriage among the four? Among the four, one is not related to the purpose of Christian marriage. I say not related to the purpose of the Christian marriage, but other 3 are relevant. Number 1, intimate companionship. Number 2, intimate championship. Number 3, rearing children. Number 4, manual support for both the husband and wife to fulfill their life callings.
Ultimate
Number two.
championships. Number 2.
Number 2, because in the exam mode, generally you will read as a companionship and you will make number 2 as an answer. And number 1 is an answer. No, not related to means intimate championship. There is no intimate championship. It is the intimate companionship would be there, which is relevant to the Christian Marriage Act. Feedback, essentially, yes? Anybody wants to say anything? Shall I proceed?
Yes, sir.
Very
Yes,
good.
sir.
Essentially, all Protestant denominations hold marriage to be ordained by the God for the union between a man and a woman. They see the primary purpose of this union as an intimate companionship, raising children, and mutual support for both the husband and wife to fulfill their life calling. In Parshuram, when you don't speak, you mute it because your children are crying. N.R. Parshuram, you mute it in your house that I can see your children sound. Mute. I say mute. You did not mute.
Okay, sir.
Because your children voice are coming to me. 15th question. Read the 15th question. Parshuram. See, I could hear your children voice again.
The
Okay,
basic
sorry.
element of marriage are find the odd man out, the parties' legal ability to marry each other, mutual consent of the parties, a marriage contract as required by the law, parental consent must be required.
4.
Option 4, sir.
Option 4 is that not odd man out. Odd man out means 3 are relevant, 1 is not relevant. That is the very odd man out means that is the answer. And that is the meaning.
Parental consent must be required.
Still, when you want to speak at the time, you unmute it. when you don't speak, you mute it. Otherwise, I get the resound to me. 16th question. Christian are governed by the Christian Marriage Act 1872. In Parshuram, you mute it. When you want to speak, at
Yes,
the
yes,
time you unmute it. Still, you did not mute it in Parshuram.
okay, sir. Okay, sir. I'm muting this.
Yes, mute. Please, when you speak, at the time you unmute it. It is not that much difficult task.
Yes.
You just touch it enough.
Yes, sir.
It provides repeat. 16th question. Christians are governed by the Christian Marriage Act 1872. It provides a code in itself and extends to the whole of India except the states of dash. Which one is correct sequence? I say correct sequence. Number 1, Cochin, Travancore and Manipur. Number 2, Travancore, Cochin and Manipur. 3, Manipur, Cochin and Travancore. 4, Cochin, Manipur and Travancore.
2, sir.
2 is the correct answer. Travancore, Cochin and Manipur. That is the sequence is given over there. And here you can see the short title. The act may be called the Indian Christian Marriage Act 1872. And supplementary question. There is no long title for this. And there is no when it is effectuated also it is not there. It extends to the whole of India, the territories which immediately before the 1st November 1956 and comprised in the state of Travancore, Cochin, Manipur. These are the sequence. Yes, anyone can unmute and read the 17th question. Yes.
17th question. Every marriage between the persons, one or both of the person whom is to or ARER, a Christian or a Christians shall be solemnized in accordance with the provisions of the next following section, and any such marriage solemnized otherwise then in accordance with the such provision shall be void as per the according to the section.
Which section says?
Option 1, section 4.
Section
Option
4 says that about that thing.
Okay. Option 1, section 4.
Number 1.
Option 2, section 4A. Option 3, section 4B. Option 4, section 5. Okay, sir.
Okay, I'm sorry that I interpreted. Yes, you have not read the options. Options should be read. I appreciate. Okay. Now the answer for this 17th question is answer for the 17th question is
Option 1.
option 1, that is section 4. So next 18th question. Every marriage under this act shall be solemnized between the hours of 6 in the morning and 7 in the evening as per the section. Which section it is? Number 1, section 8. Number 2, section 9. Number 3, section 10. Number 4, section 11. The marriage should be solemnized only in the daytime 6 hours of 6 in the morning and 7 in the evening of the Christian marriage, the Indian Christian Marriage Act says. Under the section what? Section 10.
Section 8, sir.
Section 10. T and 10, that is option 3. 18th question answer is option 3. Is it clear? Say yes.
Yes, sir.
Very good, very good. 19th question. When the Christian Marriage Act enacted in the year, when is enacted in the year? Number 1, 16 July 1872. 2, 17 July 1872. 3, 18 July 1872. 4, 19 July 1872. Which one is the correct answer?
16th.
No.
Number 3, sir.
Number 3, 18 July 1872 is the right answer for the 19th question. That is when the Christian Marriage Act enacted in the year. But if they say enacted only, suppose, supplementary question, it is effectual from I gave the false fabricated dates and I wrote the one of the option, none of the above. Then the answer is none of the above because I did not see when it will be effectuated, it came into the force. Perhaps at the same time it may be coming to the force, it seems, but specifically not mentioned anywhere. 20th question. How many schedules are there in the Indian Christian Marriage Act? 3, 1 option, 2 option 4, third option 5, fourth option 6.
I think 6 schedules.
There are 5 schedules are there, no doubt, but the 5th schedule is repealed.
So number 2 is correct, sir.
Number 2 is the right answer because the 5th schedule is repealed. So the answer is, exact answer for the question is, we are supposed to say 4 only. Okay. 21st question. Can anyone unmute and read 21st question?
Question number 21st. How many witnesses needed to in Shia law of marriages? Option 1, 2 male. Option 2, 1 woman and 1 man. Option 3, 2 women and 1 man. Option 4, none of the above. Thank you, sir.
1, sir.
1, 2, 3.
Two male, sir. Two male.
Wrong.
1 male, 2 women, sir.
Wrong. It is in
2 women and 1 man, sir.
in Hanafi marriage, at the marriage time, witnesses are
None of the above, sir.
mandatory. But in the Shia marriage, answer is none of the above. There is no witnesses should be there in the Shia marriage. But at the time of the divorce, witnesses should be there in the Shia marriage. But at the time of the divorce, in the Hanafi school, there is no witnesses are needed. That is the difference between this Sunni school and the Shia school. When I say Hanafi, it is amount to Sunni. Here, supplementary questions. How many schools are there under the Sunni law? Supplementary question. Please give me the answer.
5, sir. 5. 5.
Excuse me, I am on the online class. I will call you later. Yes. So, in Hanafi, you did not give the answer. Supplementary question. How many schools are there in the Sunni? Supplementary question. What are they? What are the schools are there in the Sunni law? There are 4. What are they? Who are they? Hanafi school, Shafi'i school, Hanabali school, Maliki school. No, sequence is Hanafi school, Shafi'i school, Maliki school, and the last one is Hanbali school. So 22nd question. How many witnesses needed in the Sunni law, Hanafi school, for the marriage? Number 1 option, 2 male. Option 2, 1 female and 1 male. Third, 2 female and 1 male. Fourth, either 2 male or 1 male and 2 female.
Number 4,
Appropriate
sir.
answer. I said appropriate answer.
Number 4, option 4.
Option 4 is the appropriate answer. Either the 2 male or 1 male and 2 females are there, but not 4 females. Is it clear? Say yes.
Yes, yes, sir.
Yes, read the 23rd question. Anyone can unmute and read the 23rd question.
23rd question. Adoption is not permitted in the personal laws of dash in India, and hence they usually go for guardianship of a child through the guardian. And what Act 1890, Indian citizens who are Hindus, Jain, Sikhs, or Buddhists are allowed to formally adopt. Option 1, Muslims. Option 2, Christians. Option 3, Paris and rivers.
Parsis.
There is Paris, Parsis and Jews, and 4, all of the above.
It's Christians.
4, sir.
4. There is no adoption in the Muslims. There is no adoption in the Christians. There is no adoption in the Parsis. No adoption in the Jews. But they can go under the Act of Guardianship and Ward Act to legalize the thing. But as per the personal laws are concerned, no adoption allowed. 24th question. Talaq is also how many kinds in Muslims and which one is odd man out? Not related to talaq. Number 1, talaq al-ahsan. Number 2, talaq al-ahsan. Number 3, talaq al-hasan. Number 4, talaq al-biddat.
Fourth one, sir. Talaq-i-biddat.
It is a kind, now it is becoming unconstitutional.
Yes.
Now it became unconstitutional, but I say kind which are related, but which is not related, I told. Among the 4. Now it became a biddat is a unconstitutional, but it was the kind at the time.
Number 2, sir.
Yes?
2.
2.
2.
There is no talaq al-e. Ahsun. Ahsun is not there. Ahsan is
Option
there.
1, sir.
No, answer is 2. Talaq al-ahsun is not there. But talaq al-ahsan is there, hasan is there, and biddat is there. But now it is become unconstitutional because of the Article 14, Article 19, and other articles they said. And Zubair Ahmed versus Ishrat Bano, that is the case law 2019, deals about what? Valid marriage, number 1. 2, divorce. Third option, maintenance. Fourth option, khula. Zubair Ahmed versus Ishrat Bano. It deals with the number 1 option, valid marriage. Number 2 option, divorce. Number 3, maintenance. Number 4, khula.
Number
Answer
2,
is
divorce.
Maintenance.
Maintenance is the answer. Because generally when you say maintenance, Shabano case will refer. I never given the Shabano case because everybody knows. 26th question. Read, anyone can unmute and read.
Question number 26, better known as the Triple Talaq case, gave India as a historical judgment which declared the practice of Triple Talaq to the unconstitutional. Option 1, Sharia Bano versus Union of India. Option 2, Muhammad Ahmed Khan versus Shabanu Begum and others. Option 3, Bhai Tahira versus Ali Isu Fidali
Hussain
Chotia.
Fidali Chautia.
Okay, sir. That is okay. Option 4,
Fazlumbi.
Fazlumbi versus K. Khadir Wali and others.
Yeah, Khadir
One,
Wali
sir.
and another.
Saheb Hussain versus Union of India.
It is the first option where the triple
Saheb Hussain versus
talaq
Union of
is.
India.
Yes, Sahara Bano, first one. Sahara Bano versus Union of India. It is dealt, it is a biddat. Talaq and biddat is unconstitutional, that is made. Okay, next. 27th question. Anyone can unmute and read.
Question number 27. In Arabia, before the advent of Islam in the 7th century CE, a variety of different marriage practices existed. The most common and recognized type of the marriage at the time of consisted of which one is odd man out? Option 1, marriage by agreement. Option 2, marriage by capture. Option 3, marriage by mahar. Option 4, marriage by succession.
Number 4, sir.
There is no marriage by succession. It's the marriage by
Succession,
inheritance
okay.
is there. Marriage by
I think
inheritance is there.
marriage
but
by
not-
capture or 2 or 3, sir. I think second one.
Answer is marriage by succession. Answer for the 27th question is Marriage by succession is not there. But what is there? Marriage by inheritance is there. Is it clear?
Yes, sir.
I removed the inheritance and I kept the succession. Though it seems to be alike, but the answer we should not supposed to make it out. What is the difference between inheritance and succession? Anyone? What is the difference between inheritance and succession? If you don't know, you say pass on. I will give the answer. If you don't know, you say pass on.
Sir, inheritance is
Inheritance
something which
means-
comes from forefathers.
So inheritance will by birth only that right will come, but succession means after the death of other person, the rights will come to the next person.
Okay. But in a simple way, can I say?
Yes, sir.
We inherit the property, I repeat, we inherit the property through succession. I repeat, we inherit the property through the succession. Is it clear?
Yes.
Yes. That is a simple way of explaining it. Of course, your explanation also I appreciate. Yes, 28th question. Which is the proper or correct sequence in chronological way? Number 1, Shafi'i, Hanafi, Maliki and Hanbali. Number 2, Hanafi, Shafi'i, Maliki and Hanbali. Number 3, Hanafi, Maliki, Shafi'i and Hanbali. Number 4, Hanbali, Hanafi, Shafi'i and Maliki. There are the 4 schools under the Sunni law.
Third, sir. Third one is the right answer.
Third one is the right answer. Hanafi. Check it once again. Check it once again.
Maybe 4, sir.
No.
Sir, it
Four.
is second.
Second.
Hanafi.
Kwanzaa, first Hanafi. Second Shafi. Third Maliki. And last Hanbali. That is the chronological order is the right. See, I say Kwanzaa because Kwanzaa means in Kiswahili first. Because I'm teaching here, no, that's why sometimes I come. Kwanzaa means first. Okay, 29th question. Who was Aisha in Islam? Number 1, first wife of Prophet Muhammad, peace be upon him. Second, wife of the Prophet Muhammad, peace be upon him. Third, wife of Prophet Muhammad, peace be upon him. Fourth, wife of Prophet Muhammad, peace be upon him.
Number 2 होगा sir. Number 2.
Wrong.
Number
one,
3.
sir. Number 1.
Wrong.
Option 3, sir. Number 3.
3 is the right answer. The third wife of the Prophet Muhammad, peace be upon him. Feedback. Aisha was one of the 3 wives of other 2 being the Hafsa bint Umar and Salama, and who memorized the Quran. Like Hafsa, Aisha had her script of the Quran written after the Muhammad's death. During Aisha's life, many permanent customs of Islam, such as a wheeling of a woman, began. What is meant by wheeling? What is meant by wheeling?
Burqa.
Burqa. That is the wheeling. Yes, 30th question. Anyone can read?
Question number 30th. What is Mubarat? Option 1. Obtaining release from each other. Option 2. Obtaining love from each other. Option 3. Obtaining passion from each other. Option 4. Obtaining tight bond from each other.
Number 4, sir.
Wrong.
Option 1, sir.
Option 1 is the correct. See, Mubarak, it is the mutual understanding by the wife and husband. Khula, it is moved from the wife for the consideration be taken from the husband to be taken, given to the husband. That is called khula. Khula. So that is
Sir, Mubarak means divorce.
yeah, it is one of the type of the divorce under the personal law, Sharia law. But here Mubarak, the offer comes from the both the sides. But the khula, the offer comes from the wife. That's why I say obtaining a release from each other means offer from the both the sides are there. So that would be the difference would be there. And with this end of it, feedback I have given. The literal meaning of the word Mubarak is obtaining a release from each other. It is said to take a place when the husband and wife, with mutual consent and desire, obtain the release and freedom from their married state. I told you that it comes from the mutual side. Offer from the wife, offer from the husband side. But in the khula, it is the offer from the wife's side to the husband to give the khula, and he will pay some consideration to the husband. So that would be the thing with this. And today, 10 questions from the Hindu law, 10 questions from the Christian law, and 10 questions from the Muslim law. That I prepared 30 questions, and at any time it will be stopped because now still 1 minute is there. But the next class, be ready to give the answer. That is the 8th one, public interest litigation. It is a public interest litigation. But tomorrow I am traveling to the Moshi. I don't know whether the places of Tanzania you know it or you don't know it. Because the Moshi also a tourist place where Kilimanjaro is a mountain or hill station is there. That is Moshi. And there I have to supposed to give some guest lecture from Monday to Saturday. But tomorrow I am traveling, so that I don't think that I will take the class because I may be in the bus at the time. Suppose if it reaches in time, that I will be tired. But your time is at the time it is 11 o'clock or 12 o'clock. For me, it is a 9:30. For me, 9:30. For you, 12 o'clock. Are you following midnight? So
Yes, sir.
perhaps I don't take the class tomorrow, but read it, and I will compensate the class on another day, because I told you no, still the date is not given. Is the date is announced? Examination
No, not
is
yet, sir.
not announced. As far my knowledge goes, examination date is not announced. So I can compensate tomorrow class on the other day, or if the date is extended over there, instead of 24 days, I will teach the 25th day, because tomorrow that I am not going to deal. With this, I would like to stop my today's sharing. Have a good day. Jai Hind.
जनगणमनाधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंग विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभाशीष मांगे
जय हिंद। सारे जहां से अच्छा हिंदुस्तान हमारा।